Florida Estate Litigation, 57105 and Sanctions. Hello, my name is John P.L.C. I'm going to be speaking to you today about a 4th District Court of Appeal appellate opinion that was just released literally a couple of hours ago regarding statute 57.105 under Florida law, as well as an appellate opinion on summary judgment and what can happen when you're in the middle of a trial and what can happen in the course of an appeal. Now, this is not a probate litigation case, but it's very important to understand and for your probate litigation law firm in Florida to know if you're in the middle of a probate dispute or an inheritance lawsuit. My name is John P.L.C. I'm a probate litigator who practices in West Palm Beach, Florida with the P.L.C. law firm. Our trial lawyers handle disputes, trials, and appeals involving wills, trusts, and estates. This case is the Hibbs Grove Plantation Homeowners Association versus Aviv, A-V-I-V. It was issued today, May 11, 2016, by Florida's 4th District Court of Appeal. Florida's 4th DCA is the appellate court that hears appeals from Broward County, Palm Beach County, and Martin County. They're on Palm Beach Lakes Boulevard in West Palm Beach, Florida. This is a case involving some homeowners and a homeowners association. The homeowners association evidently sued the homeowners, saying you have failed to pressure treat or pressure wash adequately your part of the building. A lawsuit ensued in Broward County. The homeowners said, hey, no, we pressure treated it. We complied with what we were supposed to do. The homeowners evidently didn't like that and said there's still mold and mildew there, and the pressure treating didn't work. The court, on its own action, awarded sanctions against the Homeowners Association under 57105. Now, Florida probate litigation law firms will understand that 57105 is a statute that permits a party that is raising an issue without basis in fact or law to be sanctioned, usually in the form of attorney's fees for filing or maintaining a frivolous lawsuit or position. Florida 57.105. So 57105, if you file a lawsuit or you maintain any position during the course of your Florida litigation that is not based on law or fact, the other side can send you a letter and tell you to stop it and tell you to remove the assertion that you're making that they think is frivolous or baseless. If you don't do that, a motion can be filed, and the court can award attorney's fees in the form of a sanction for not removing something that's frivolous or has no basis in law or fact. 57.105. Well, in this particular instance, the trial judge did it on its own volition. Also granted summary judgment on the matter. It went to the 4th District Court of Appeal, which reversed. And the 4th District Court of Appeal said that the summary judgment was improper, and also that the sanctions were improper under 57.105. Now this case will go back to the trial court. So if this is a homeowners association, what's a Florida probate litigation attorney in Florida doing talking about that? Well, in Florida estate litigation, many times family members have lots of emotion, sibling rivalry, even jealousy. Second or third marriages, adult children from a prior relationship, we get emotional. And sometimes allegations are made which are not supported by the facts or law. If you're making an allegation or taking a legal position in your estate litigation that is not supported by the facts or the law, you can be sanctioned for that. You should not be doing that. You should be making allegations that are based on the truth, the facts, or you should have a very good faith belief about the allegations which you're making. If you make an allegation where there's no basis in law or fact for that, you can be sanctioned either by the court on its own volition or by another party filing a letter and later a motion under 57105. But remember, even if there's no 57105 letter or motion that's been filed, a Florida probate court in any estate or inheritance lawsuit can, by its own inherent authority, sanction bad conduct. So be careful of that. So this case, I think, is an excellent example of why parties should sometimes mediate some disputes. It sounds like this whole dispute from this 4th District Court of Appeal was about pressure cleaning the side of a condo, and whether the pressure cleaning of the condo or the residence removed the mildew and removed the stain. So you've got these parties that are involved with the trial judge. Now there's an appeal. It's expensive. There's attorney's fees. Perhaps this case should have been mediated if it wasn't. The opinion doesn't tell us if it was mediated or not, but sometimes a mediation conference can actually help the parties come together and resolve dispute, minimizing attorney's fees and giving everybody some certainty and resolution. My name is John P.L.L.C, and this concludes my remarks about this Florida probate litigation topic.